in CR 19-0531, State versus BERMEA. As I'm sure you are familiar, each side has a maximum of 20 minutes for argument. We don't require you to use all of that time, although you are free to do so should you want to. As is per usual, appellant, you may reserve some portion of your time for rebuttal, although you're responsible for managing your time. And because we are handling the argument remotely, we thank you for accommodating that. I will be keeping time manually, and I can periodically alert you of your remaining time. You should also feel free to run a timer on your own device as you see fit. Feel free to ask for an update of time remaining at any point. We are recording this argument, and it will ultimately be posted to the court's YouTube channel. And so for the clarity of the record, if you could please identify yourself and your client as you begin speaking. We, of course, hope that no connection failures occur. Should one of the judges lose a connection, that judge will review the recording later. Obviously, if one of the attorneys loses the connection, we will suspend the argument and return to it once we've regained that connection. With that, please keep in mind that we've read the briefing, we've studied the record in the case, we've conferenced the matter this morning, and you may proceed.
Thank you. I am going to set my own timer. Thank you.
Sure.
Good morning, Your Honors. Donnie Husted appearing on behalf of Ryan BERMEA. Your Honors, there are two tremendous injustices that occurred during the trial and aggravation trial for Ryan BERMEA. I requested this argument to address one, the denial of Ryan's right to testify during the aggravation trial. This is a gross injustice, but for his lack of testimony, the jury may not have found the gang aggravator proven. If there had been no gang aggravator proven, then he would have been probation eligible. Instead, Ryan is now serving 7 years. This injustice requires that this court remand for a new aggravation hearing. Ryan did not waive his right to testify during the aggravation hearing. This is a personal fundamental right that only Ryan could have waived, but he did not waive that argument, or he did not waive that right. The chain of events leading up to the trial court's denial of Ryan's request make this clear. The first thing that happened is that at some point, not on the record, the defense attorney and the prosecutor agreed with each other that no witnesses would be presented during the aggravation trial. The record suggests, by everything that happened thereafter, that Ryan was unaware of this agreement that his attorney had made. The second thing that happened in the chain of events. Yeah.
So what would have happened if your client had testified and the judge found favor with that testimony? What would have happened?
Well, Your Honor, the aggravation trial was in front of the jury, and so I'm not sure that the judge would have had.
Well, jury then.
Okay, certainly. Well, if they would have found favor with him, then they may not have found that aggravator proven. And had they not found that aggravator proven, he would have been probation eligible. That is an absolutely huge injustice and prejudice to my client, who had before this had no criminal history. He, as the record indicates, what he probably would have testified to is everything to rebut what the state's expert had said. And that would be that he left the gangs years ago. He got married. He had 4 children, 3 with special needs. That influenced him to continue leaving the gang life. He got sober. He participates in all sorts of services. He works as a mentor. I mean, he very easily could have presented enormous, a lot of additional evidence that I think, in my opinion, would have swayed the jury.
Go ahead, Judge.
And he did not testify to that at trial?
No, Your Honor, he did not testify at trial. And it doesn't appear that he asked to testify. I'm not sure what led him to want to testify during the aggravation phase, but that is where we are right now. And
counsel, sorry, go ahead.
No, I'm sorry, go ahead.
No, go ahead.
Just to understand, based on the conviction, the findings at trial, could the jury have found differently on the aggravator, or wouldn't that have been an inconsistent verdict? Or I mean,
No,
an inconsistent finding?
No, not at all. He was charged, the indictment charged him under ARS 13-1202A3. And it also noticed that they were, it noticed the aggravator under 13-714. Now, 13-1202A3 says that a person is guilty of threatening and intimidating if they threaten and intimidate by word or conduct to cause physical injury in order to promote, further, or assist in the interest of a criminal street gang. Okay, that's the difference. At the 714, the 13-714 says that they are guilty of that, or that aggravator is proven when the jury finds that they committed the offense with the intent to promote, further, or assist any criminal conduct. The difference is to the interests of the gang, or were they helping with criminal conduct? That is the difference. And the jury instructions that the jury received in the guilt phase, the jury received instructions that simply said assist in the interests of a criminal street gang. They did not receive the instruction for 13-714 until the aggravation phase. 13-714 is what puts the teeth on this gang, on the gang crime. Other than that, the class 3 is a regular class 3. And as a first-time offender, he would have been eligible for probation.
Can we talk about the record in terms of any waiver on the part of your client? So your position is that he never waived his right to testify at the sentencing portion in front of the jury, and that defense counsel and the prosecutor are the ones who entered into this agreement. Talk to us about what statements he may have made that could be relied on as waiver, and why they're not.
Okay, I think there actually are no statements by my client. A lot of the cases that deal with this issue talk about that the client, especially when the cases that find that the defendant waived his right, most of those cases involve the defendant being very boisterous during trial, willing to speak up, saying things. So they're saying he talked throughout trial, so certainly he would have made it known to the judge at some point that he wanted to testify. Here, Ryan didn't say a word. We have nothing in the record that says he waived his right. Now, the first thing we know is that, going back to the fact that they made the agreement, and then the one time that the judge discussed it with the parties, Ryan was not present. And then the next time it came up was immediately after the jury rendered a verdict, the jury was pulled, and the judge in the very next breath said, okay, now we're going to do the aggravation phase. And Ryan may not have understood what was going on at that point. And the fact is, it went so fast. So they go through this aggravation phase. She immediately enters the aggravation phase. They read the jury instructions. The prosecutor presents his argument, and then Ryan lets his attorney know at the first possible opportunity, I want to testify, So the attorney gets up and basically says to the judge, my client wants to testify. The judge denied him that right based on a perceived waiver, but there was no evidence he had waived it. What we know is that at this point, we know there's some sort of disagreement. Attorney didn't want or think he was going to testify. Ryan's like, yes, I am. And the judge needed to inquire. This is one of the situations where the court has a duty to actually inquire into whether or not the waiver was made.
Mr. Stead, I'm sorry, go ahead, Randy.
Counsel generally can, clients are generally bound by their actions of their counsel in the conduct of trial, and I understand that that's different when the defendant chooses to testify. But the cases generally are testifying at trial. And what we're dealing with here is testifying at the sentencing hearing. Is the law and the analysis the same?
You know, as I mentioned in my request for the oral argument, this is an issue of first impression for Arizona. We don't really have any cases that talk about testimony at the aggravation phase, but it is as important and it is as much of a constitutional right as testifying at trial. And in fact, in this case, Ryan, it cost him years in prison as opposed to being able to get probation.
Counsel, do you have to make a showing that it did cost him that, or just merely that it could have? And as part of that, I'd like you to clarify for me what you view as the standard of review. Are we looking at this as a fundamental error? Is this harmless error? Any of which require a showing of prejudice. So I guess I'd like to focus a little bit more on the prejudice aspect. I know you've talked about probation eligible being the key difference and the prejudice, but what would he have said that the witnesses who testified on his behalf, who testified to his lack of current gang activity, what would he have said to make a difference? And do you need to establish that?
And may I ask for clarification? You said the witnesses that testified on his behalf, or did you mean he testified?
No, I mean, like Maureen Pass testified or spoke to the court. Diane BERMEA, I think, and they raised with the court the at least the asserted facts that he was no longer involved in the gang life, that he was a family man, those sorts of things.
Now that is correct, but that happened at sentencing after the aggravator was found. And so that made no difference whatsoever. It was too late. Okay. So the prejudice in this case, yes, it is harmless error review. And, but this court looks at the constitutional issues de novo. And Arizona doesn't have any cases specifically on a client's right to testify, but the Ninth Circuit is very clear that the Court of Appeals reviews de novo the question of whether a trial court suppression of a defendant's right to testify is, violated his constitutional right. So, and I apologize, I sort of lost my train of thought, but we're talking about the prejudice. So here, the prejudice is clear because he was the only person that would have testified as to his actions since leaving California. And he never had the opportunity for the jury to judge his credibility and decide maybe he is more credible. And we know that the jury had some issues with the intent, because their first question during deliberations was, are we dealing with intent? And they seemed to not understand what it was they were trying to find. And they asked the court, are we dealing with intent? And of course the court answered appropriately and just gave them the jury instructions again, or told them to refer to the jury instructions. But it's clear that intent was something they were talking about. And that is exactly what Ryan would have testified to. Because what we have here is we have a young man who he's left the gang and he's made a different life for himself. And he has 3 special needs children, and he goes to pick them up and he sees an older kid hit one of his special needs kids with a stick. And he is livid. This child can't protect himself. So he is Papa Bear. And as Papa Bear, he walks in and he is angry and he's stupid because he should never have pointed to the tattoo and said, yeah, you know what this means? He never should have said that, because that is threatening and intimidating. That is wrong. But the point is, he didn't do it thinking I'm going to promote the gang. He didn't do it in order to promote the gang. He did it because he was angry because he perceived his child not being cared for properly.
But for that reason, he connected himself to the gang and brought the force of his gang, past or present gang membership, as part of the discussion. Did he not?
I think arguably yes, but that still is not promoting the interests of that gang. And that really goes to what the jury is going to decide. Maybe the jury would have found him guilty. Well, I mean, I guess they did find him guilty of the class 3, and we're not dealing with the other issue. But the So, you know, they said, yeah, he did it with the interest of, to help the interests of the street gang. But with the aggravator, they had to prove that he did it to promote and assist in criminal conduct by the street gang. The only criminal conduct was his behavior there at the daycare. So they really needed to find, the jury would have had to find that that criminal conduct was at the behest of the street gang, and it was not. And may I ask how much time my phone keeps going dark?
You have 5 minutes, 50 seconds.
I would like to reserve the rest for rebuttal if that is all right. Yep. Thank you very much.
Thank you. May it please the court, Eric Nobloff for the Arizona Attorney General's Office representing the state of Arizona. On both issues that BERMEA raises to this court, the trial court did not commit reversible error. If we look at the first issue, there was no error here because BERMEA's request simply came too late. In the cases that defense counsel cites in the opening brief, Martin and Gobronson, our Supreme Court has said in both cases that the defendant must make his desire to testify known at trial and cannot allege it as an afterthought. In Martin specifically, the court noted that the defendant had constantly and vociferously requested to take the stand. But that is not what happened here. Nothing in the record. No.
Well, counsel, I take those cases as correct, but they deal with testifying at trial. The issue here is testifying at the aggravation hearing, and it seems like that the defendant made his wishes known as soon as he could. I mean, are you saying that unless a defendant wants to testify at trial, that he's waived his right to testify at the sentencing hearing? Can't the defendant make the strategic choice? I'm not going to testify at trial for any number of reasons, but I want to testify at sentencing.
I think he can strategically decide not to testify at trial, but then decide that he did want to test at the aggravation. But there is nothing on the record to indicate that he, as in Martin or Gobronson, that he timely indicated to the court that that's what he wanted to do. Instead, what he did was he waited until after he heard what the state had said in closing argument, and then decided that he wanted to say something. And I know defense counsel also asserts that Gobronson requires the trial court to inquire into whether or not the defendant had waived his right to testify. But that's just not simply what the case law or the record here supports. Gobronson says that there is no duty to inquire under Arizona law. And while some cases it may be inappropriate, that's not the case here, because the trial court had no indication that the defendant wanted to testify. Instead, the defendant hadn't testified at trial. Both parties had stated that they were going to proceed via argument and not put forth any evidence. The trial court announced that decision in open court, and then the state began its argument. And it wasn't until defendant heard that argument that the defendant raised to his defense counsel that he wanted to state that. And even defense counsel, and this is the only record that we have about the inner workings between defense counsel and defendant, he said completely unbeknownst to me. So that vote.
Counsel, was the defendant present at the beginning of the sentencing hearing when counsel said we're not going to present?
So there was no indication that he was present at the time that the party specifically informed the court. But I do believe he was present when the trial court announced to the open court that the parties had decided not to put forward any evidence, to just proceed to argument.
So your argument is if he had objected or said at that time, hey, I want to testify, then it would have been properly raised.
Correct. Yes.
So, then the state's position obviously is that defense counsel, in the absence of the defendant, can waive his right to be heard at the aggravation phase.
Could you repeat that question, Your Honor?
Your position is that defense counsel, in the absence of the defendant, can waive his right to be heard at the aggravation phase.
So long as we don't have anything on the record to say otherwise. I know Martin talks about that there was some apparent conflict between defense counsel and defendant that was visible on the record. And again, I think the court noted that the defendant had constantly and vociferously requested to take the stand throughout the trial. And
but how would we see that conflict if the defendant wasn't even there?
And you know, that could potentially be where defense counsel notes that, you know, defendant did want to take the trial, but we disagree. Or at other opportunities, for instance, when the trial court announced to open court that the parties were going to proceed by argument only, the defendant could have then raised and said, hey, wait, I do have something that I want to say. And again, on this record, the only evidence that we have about the internal discussion is the fact that the defendant said that he wants to say something completely unbeknownst to me. So that evinces almost that they didn't have, that defendant never told defense counsel, hey, I do want to in fact testify.
So when we have, isn't it possible here that perhaps defense counsel mistakenly understood, because we don't know what the discussions were, or if there were any discussions between defense counsel and the defendant, isn't it possible that defense counsel misunderstood when the defendant said, I'm not testifying at trial, and just kind of assumed I'm not testifying at all, period, at any stage? I mean, that's a possibility of what could have happened here, right?
It could be a possibility, but unfortunately in this forum, it would be inappropriate to try to determine what was going on between defense counsel and defendant. That would be more appropriate for an IAC claim, where they can go into like an ineffective assistance of counsel if there was some disagreement. But unfortunately here, all we have to go is what is on the record. So then that goes to my next question. When the court, putting ourselves back into the aggravation phase, when the court doesn't know what information the defendant may or may not have received in terms of this right to testify at his aggravation hearing, shouldn't the court have obtained a waiver directly from the mouth of the defendant and said, you do understand you have the right to speak and to testify at this separate proceeding? And will you waive that right? I would think the best way to look at that is if we put ourselves at the trial court at the time where the trial court announced in open court that the parties were going to proceed by argument only. And at that time, we don't have this benefit of hindsight that we know after the state presents their argument, the defendant is going to explicitly say, hey, I would like to say something. Instead, all we have is the fact that defendant didn't testify at trial. There's no indication up to that point that defendant wants to testify during the aggravation hearing. Instead, all we have is defense counsel's position that they were ready to proceed by argument only, and nothing else on the record that says otherwise.
Counsel, and so let's assume for a minute that we find that this was error, that the court had a duty to inquire. Can you talk to me about the prejudice aspect of this? First of all, do you agree that this is a harmless error analysis?
The state's position is because it was belated that it's under fundamental error, but even if this is under an abuse of discretion standard, there is no harm, or it is harmless. And the reason is because the enhancer was inherent in the trial's verdict. And I know defense counsel is now stating that there are differences between the statutes, but in the opening brief and the reply brief, they enunciated that it was virtually the same. And I would also note that this court has found that that those elements are the same in a case, State versus Harm, which is 236 Ares 402. And the court stated that it would be illogical to find that the defendant's sentence was improperly enhanced based on an intent to promote, further, or assist any criminal conduct of a criminal street gang, where the jury in the same proceeding convicted the defendant of a crime which required it to find that same intent. And so here, there would, even if the court didn't have didn't hold an aggravation hearing, there would have been no error.
Just to clarify, under 13714, when the statute speaks to further criminal conduct, whose criminal conduct is it talking about? The gangs or the defendant's own?
The state would assert that it would be the gangs, same as in the offense statute, the interest would be the criminal street gangs' interests. And that was furthered, and I can get into that in the second issue if you would like to turn to the second issue.
Well, but just before we jump to that, so I didn't see anywhere in the briefing this new point about probation eligible, but could you please respond to that, that the prejudice is that the jury may not have found the aggravator, and in such circumstance, their defendant may have been probation or would have been probation eligible.
That is correct, that the enhancement under 714 made BERMEA no longer probation eligible and increased the sentence by 5 years, sorry. But the jury is unaware of what that potential sentence is and what the probation. So I don't think it's appropriate to consider that into the factor, because the jury's not aware of the ultimate sentence for a reason.
What does Mr. BERMEA have to establish to prove prejudice here? Does he need to establish that there's the mere possibility that he could have had the aggravator not found, or does he have to establish that it is likely? What does he have to prove?
I would think that under a prejudicial standard, I don't think that there is anything that he could point to that would prove it, because the trial court didn't even have to have an aggravation phase, because the enhancement was inherent in the trial court's verdict, or in the jury's verdict, excuse me. And so because it was inherent in the jury's verdict, the jury had found those elements.
Okay, unless somebody...
Is that why the party counsel at least agreed not to present evidence at the aggravation phase?
I'm not sure what the inner reasoning is, but I would think that probably would be the reason that they just put on argument and not any additional evidence. And then quickly turning to the, and actually, can I get I'm not sure how much time I have left.
You have 7.5 minutes.
Okay, perfect. Thank you so much. Quickly turning to issue number 2, any inadmissible testimony, BERMEA cannot establish prejudice, because he cannot show that the jury's verdict could have been different, given the fact that the inadmissible testimony was minor in comparison to the 7-day-long trial, where there were numerous officers that testified, and that all those officers' testimony showed that making a threat is a form of promoting and supporting the gang, because it instills a sense of community fear of the gang and gang members that makes it easier for the gang to commit the crime. And over the years, he continually told officers that even though he wasn't an active participant in the gang, he would still always represent the gang. He would still be a part of that gang and would always do things to support that gang. And then he also, Detective Bent testified that BERMEA admitted to him that he intended to scare Becerra when he pointed to his gang tattoo, thus putting the full force of the gang behind him in that threat. And it worked. Becerra stated that she was terrified and scared to go to work and to get out of her car, and that even though she never saw BERMEA again, she was at a Fry's and saw somebody with the same gang tattoo and became instantly terrified. And this is exactly what the legislature's purpose in enacting this enhanced sentence is to prevent somebody from using a gang to make their offense even worse. And it's almost akin to the use of a dangerous instrument or a gun that makes a crime that much more dangerous. And ultimately, BERMEA cannot satisfy his burden of showing that a reasonable jury could have found differently. If there are no further questions, the state respectfully requests that this court affirm BERMEA's convictions and sentences. Thank you.
Thank you.
Thank you, Your Honors. Donnie Husted for Ryan BERMEA. And my clock isn't working, so if you could hold your hand up when I'm done, thank you. Just briefly going to the inadmissible testimony as to the ultimate issue, or actually to the mens rea of the ultimate issue. The state talks about how it really hardly matters because it was a minor portion of the trial. It doesn't matter how much time it took when a detective who has the full force of the state behind him and 24 years of experience and has been discussing how gangs act, how gangs behave, what gangs look like, what gang members do, which is all appropriate. When he then says, in my opinion, Ryan intended to promote his gang when he pointed to his tattoo, he's talking about intention. He's talking about mens rea. He is talking about, in my opinion, he's guilty. That's all.
Well, Counsel, but there was other testimony to the same effect, I understand. So if I anticipate going to say he's an expert, so his testimony carries more weight, but the jury heard all that evidence and gave it the appropriate weight. It sounds like, I mean, argument could be made that's merely cumulative.
No, I don't.
Well, didn't the defendant speak to that himself in statements to the police?
Well, no, he never said, let me back up. He never said, okay, I apologize. Going back, the statements to the police were years earlier, about 5 years earlier, I think, or 4 years earlier for the most recent one. And he never specifically says, I am going to commit crimes for them. He, in fact, told one of the officers, and I apologize, I don't recall who right off the top of my head, but he told one of the officers that he doesn't bang anymore. In other words, he doesn't participate in their activities. He's down with them. In other words, this is where I'm from. This is my brothers when I was growing up. I left because I couldn't be there anymore. Not good for me, but I left, but they're still my brothers and I support them. But he's not saying I'm going to go commit crimes on their behalf.
Well, but Counsel, the detective, as I understand the record, and correct me if I'm wrong, the detective testified that the BERMEA admitted to him that he pointed his tattoo knowing it scares the hell out of people.
I don't recall seeing that in the transcripts. I believe he said he pointed to the tattoo. You could be right, and I apologize. I just do not recall that exact statement.
Go ahead.
We'll confirm that for the record, of course. But if that is true, then that comes out of your client's mouth. Isn't that more probative than the detective's own opinion?
I don't think so, because the detective said 3 different times that Ryan was guilty, and the jury may have believed, but for that, the jury may have believed this is a father who just lost his cool, said some stupid things. He's not rolling with the gang anymore. The gang's in California. There are no ties for that gang here in Arizona, unless you make this bizarre leap that the gang cops always do about how the Sureños are infiltrated with every single gang, and so the Sureños are the gang in Arizona. I mean, it.
All right, I have a question though. I find your argument that the gang aggravator may not have been proven to the jury and therefore he would have been probation eligible. Why is that not part of your briefing?
I overlooked that, and that is my error. And I overlooked that. That came to me as I was going back and doing some moot arguments and going through everything again. And it started.
So where does that put the state in terms of being able to defend that?
I understand that. And
could we find waiver of that argument for appeal purposes?
I don't think so, because jury instructions are incorrect. Jury instructions are reversible error. And
right, but you're hearing about it at oral argument for the first time.
So I guess, I mean, I guess we'll probably be back here on Rule 32, but yes, I mean, I understand that there could be waiver based on the fact that I did not brief that issue.
All right, thank you.
You have
Counsel.
10 seconds.
Okay, then that's fine. Thank you so much for your time today, Your Honors.
Thank you.
Thank you, counsel, both for your arguments. We will take the matter under advisement and issue our decision in due course. Court is adjourned.
Thank you.
Thank you.